Okay, well, before we begin, I would like to remind our spectators that their microphones should remain off at all times. For judges and participants, please keep your cameras on and microphones should be on mute when not speaking. All present. Session 3 in the Dr. D. Creedon courtroom of the Walker-Moot Supreme Court is now in session. It is with great honor and privilege that I present Adam Kanji, Lensler Slot, Kate Aguirre, Kelly Santanini, and Dr. David Creedon presiding. Your task, the justices of the panel, I present to you, speaking on behalf of the appellant, Mrs. Armstrong, in today's matter before the court, Isabelle Santerre and Jean-Michel Dako, and speaking on behalf of the respondent, Dr. Ward, Tess Chambers, and Veronica Attia. We are here today to determine the outcome on appeal before the court on the matter between Mrs. Armstrong and Dr. Ward. Both the appellant and the respondent's counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to the court, including any questions arising from the bench. The appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there is a 5 minutes left to speak, and appellants, will you be using your 3-minute rebuttal?
Yes, we will.
Thank you. The court now invites counsel for the appellant to begin.
Perfect, thank you. Good morning, Your Honors. My name is Isabelle Santerre. Allow me to present to you my colleague, Mr. Jean-Michel Dako. We represent the plaintiff, Mrs. Armstrong. The present case deals with medical negligence, more specifically, the breach of the standard of medical care. We will present 2 arguments to this honorable court, the first of which relating to the standard of care, and the second of which relating to the standard of review. I will address the first point, specifically, the fact that the standard of care is a question of execution and not intention. And I will also present that causation can be used as a useful tool to determine the standard of care. My colleague will then address that the ruling out of non-negligent causes should be a burden for medical professionals when evaluating the standard of care. He will also present our second argument pertaining to the majority's error in applying the standard of review. Now, on to the evaluation of the standard of care. The Anse-Cooper test has remained one of the most useful tools available to Canadian courts in cases of negligence. The Anse-Cooper framework highlights the necessary elements of successful action and has recently been used in the 2017 Deloitte & Touche versus Livent case. In this case, the Supreme Court reaffirmed that there are 4 steps in affirming a successful negligent action. A plaintiff must demonstrate that 1, the defendant owed him or her a duty of care, 2, the defendant's behavior breached that very same standard of care, 3, the plaintiff sustained damage, and 4, the damage was caused in fact and in law by the defendant's breach. The Anse-Cooper framework also establishes a long analysis in order to determine the prima facie duty of care. It involves steps and elements to which people can utilize to find this duty of care. However, in terms of analysis of the standard of care and its relation to causation, improvement and clarity are much needed. That is precisely what we are asking of this honorable court today, is to give us precision and clarity based upon these factors. Typically, in cases of negligence in which the standard of care is debated, the doctrine of the reasonable person is utilized. The reasonable person is a concept that changes in accordance with each case. In cases of medical negligence, the reasonable person is given the attributes of the defendant. So, the standards are often higher given the expertise of that person. In cases of medical negligence, it is common practice for expert witnesses to testify what a reasonable person with the same expertise, same education, same training as the defendant would have done in this same situation. In Chanin versus Bell, it was established that the test laid down by the Supreme Court of Canada is a threefold one. 1, the surgeon undertakes that he possesses the skill, knowledge, and judgment of the average surgeon. 2, in judging that average, regard must be had to the special group to which he belongs. From a general practitioner at a rural point, A different standard is exacted than from a specialist at an urban point. 3. If the decision was the result of exercising that average standard, there is no liability for an error in judgment. It is also important to highlight that in Salmon on the Law of Torts, it is stated that doctors, surgeons, and dentists alike owe to their patients a duty in torts as well as in contracts. It is expected of such a professional man that he should show a fair, reasonable, and competent degree of skill. It is not required that he should use a highest degree of skill, or for there may be persons who have a higher education and greater advantage than he has, nor will he be held to have a guaranteed cure. Now, in this specific case, the majority erred in assuming that this standard is one of perfection. It wasn't a standard of perfection that was asked of Dr. Ward, but rather one of reasonability. A surgeon is trained to work in high-risk environments with precision. Therefore, when it is known that a tool such as the ligature tool can cause injury to structures within 2 millimeters from it, it is logical that a surgeon wielding that very same tool should stay away from any other structure. And
Counsel, isn't the evidence that Dr. Ward did take all of the appropriate steps to stay away and something just went wrong? So isn't this what we ask physicians to do every day? It's take the appropriate steps. Sometimes things just happen in medical cases. And why does that necessarily lead to negligence? That seems to be where you're going down, the road you're going down. That execution actually is what matters more than the actual process itself.
Well, in fact, so Dr. Ward stated that he did follow steps to avoid injuring Miss Armstrong, but the Court of Appeal accepted that Dr. Ward intended to use proper technique and execute this technique properly, but he didn't. The intention is not enough. It's uncommon in cases of medical negligence that a defendant has missed every single necessary precaution needed to uphold the standard of care and has been intentionally reckless. If a standard of care could be held up by the mere intention of holding it up, no victim would ever be able to see justice. So in this case, what we're trying to make this honorable court understand is that setting an appropriate standard of care for medical negligence in Canada is of the utmost importance, since the primary goal of torts law is to compensate the victim for the damages they have suffered.
But not if a reasonable person would have taken the same steps. What I'm having some trouble with is we've always in Canada used a process-oriented approach to negligence rather than the outcome approach that you're suggesting. And it seems like you're suggesting a radical revamp of standard of care when it comes to medical negligence. And I'm just not sure how doctors can be expected to protect themselves against this.
Yes, of course. Actually, that is my next point, treating on causation. So just not necessarily an entire revamp, but in certain cases of medical complexity, we are proposing that causation can be a useful tool to determine that very same standard of care. But to answer your question briefly now, in the case of Mrs. Armstrong, those steps were followed. She was injured and she had a benign colon as well. There were no other structures that were peeking out or anything like that. So when you explain that accidents happen, well, that's precisely why torts law exists, is to protect those victims of those accidents from quite those situations. But if you'd allow me to continue on with my next argument on causation, I think I can offer up some clarity, if that's all right, Judge Kanji.
Go ahead.
Thank you so much.
Counselor, may I ask a question, please?
Yes, of course.
What was the original indication for the colectomy?
Sorry, could you offer
The
detail?
the indication for surgery was doing a colectomy on a benign colon. What was the original indication for the colectomy?
I'm not quite sure. I'm not sure.
Why was the colectomy done?
I'm not sure if my co-counsel would be able to answer this question at all, or if
You think this is pertinent or not pertinent to the overall case?
I think it's pertinent. I think it's a pertinent question. However, that being said, it's a routine surgery that other people undergo often enough, and that Dr. Ward had performed prior to this surgery on Mrs. Armstrong, and she was explained that the risks of this surgery were were rather low, and the outcome of the surgery ultimately was that she ended up losing a kidney from this surgery. So I do think, Justice Creighton, that it is an important point, but unfortunately, I do not currently have the facts at hand to be able to pinpoint.
My second question, thank you. My second question is that in your factum on statement 17, the presiding judge accepted that Dr. Ward took the steps to identify and protect the ureter, and then goes on and says, but concluded that he had failed to do so. So I'm not sure, those are two, from my understanding, those are two opposing statements. How do you reconcile those two statements?
Yes, of course. So how we reconcile those statements is that actually it goes with the causation, but if an injury arose out of the surgery, and though Dr. Ward is reticent to admit that he did go too close, there is evidence that supposes that that injury would not have occurred had the ligature device come within 2 millimeters. So though the steps as set out, I think it's at step 43 of our factum, one of these steps is to identify the left ureter by locating it on the screen in the operating theater, and then tweaking it and pushing the structure around to ensure it moves, and then pushing away the structures, including the ureter, towards the head of the patient from the colonic mesentery.
Yes, I understand all that, but I just don't see how the two statements can be linked together. I mean, on one hand, the presiding judge said that all the steps were taken, and on the other hand, that he caused the injury. So, I mean, how do you reconcile that? I don't get that.
Well, there's a difference between attempting to take a step and executing it properly. So though he may say that he took steps, it's the execution that matters. And in this case, the execution was not fully fulfilled, seeing as she did suffer those injuries. If there are no further questions, I would like to move on to my second argument. Sorry. Thank you. So it is important to determine how causation and the standard of care are to be treated. Each element used to prove a successful action of negligence is connected to each other. Is the order in which these steps of analysis performed important? Can causation be used as circumstantial evidence to inform the standard of care? The but-for test is usually what is used to determine causality. However, due to the complexity of many medical negligence cases, proof of causation often requires expert evidence. In the Court of Appeal, the majority supposed that the trial judge had used an outcome-oriented approach in which he used Mrs. Armstrong's injury as a means to prove a breach in the standard of care. However, in her dissent, Justin van Rietzberg established that generally the standard of care must be determined before causation. However, in certain instances, such as this one, it is sometimes necessary to utilize causation as circumstantial evidence to determine if a breach of standard of care really occurred. In complex cases, the uses of causation as evidence can be necessary to fully understand the context and details of the situation. During an examination of expert witnesses, various theories regarding Mrs. Armstrong's injury arose. Some supposed that the ligature device had come within 2 millimeters of the ureter, while others proposed that while carefully maintaining his distance, the ligature device caused scarring through heat dispersion. In order to determine the standard of care acceptable in this situation, it was necessary to observe the proof of causation, which demonstrated whether an appropriate distance was maintained or not. We ask this honorable court to allow the use of causation as circumstantial evidence in determining the standard of care.
In all cases or in specific cases? And if it's specific cases, what would you propose we look at to determine whether causation should be used to inform the standard of care?
Yeah, of course. So specific cases where the root cause of the injury can sometimes be complex, and there are various elements that could contribute to it. So those cases would be some that could benefit from using causation as circumstantial evidence, because they would be able to see how the procedure went and understand whether those components contributed to the prejudice. However, those are cases of complexity, where there's a case where perhaps the wrong hand was amputated or something, those cases perhaps won't benefit from using causation first, but that is what we suggest.
Counselor,
Yes.
with respect to the causation, the etiology of the damage to the ureter, what evidence do you have that thermal injury caused the obstruction in the ureter? Do you have any corroborating evidence that there was thermal injury? For example, was there any pathology reviewed? Do you have the pathology to substantiate or to refute the etiology?
Well, that is a question of fact, which was agreed upon in the trial, the first trial decision. So that is not something that we are touching upon. It is assumed at this point that it was scarification that caused the injury, and that was subsequently caused during the surgery. Now the question is whether that is negligent or not, but that is a question of fact that we are not touching upon. We are touching upon errors in law today.
So just to be clear, the pathology did corroborate or
Yes.
identify that thermal injury was the cause of the damage to the ureter.
Yes, expert witnesses did agree upon the fact that either by using the ligature at 2 millimeters away or through heat dispersion, the scarring was caused by some kind of heat source, whether it's the ligature applying directly on it or from heat dispersion from using the ligature device further away.
Counsel, I'm just going to ask you, when you're speaking about causation in that case, something that I will be asking both sides to consider, I'd like to hear from you if the actual act of not injuring the ureter itself, not injuring the ureter, to you, are you telling us that you think that that is a step or of the goal of the procedure, and why would that matter?
Well, the goal of the procedure is a colectomy. So the goal is not necessarily to avoid all other structures, but the fact is that causation can be used to determine whether that appropriate distance was maintained and what truly happened during the surgery. It's extremely difficult to establish a standard of care without having knowledge of what has occurred. I see that time has elapsed. So I think perhaps we can continue on this point during the rebuttal, but I'd like to give the floor to my colleague.
Understood. Before you begin, I would like you to consider the end of that question from your side, from the party. Would you consider not injuring the ureter as a step or a goal? And what part of that is important for the court's consideration today?
Since it's my turn now, I'll definitely talk about it further down in my arguments. And if it doesn't reply if it doesn't answer your question, please ask it again, and I'll gladly answer it when the time comes. Your Honor, my name is Jean-Michel Dako, and as my colleague mentioned, I will be presenting the second part of our argument in a way that will demonstrate why this courtroom should reverse the decision of the Court of Appeal and affirm the trial judge's conclusion in which he found the respondent responsible for breaching the standard of care and with an act of negligence causing the appellant's prejudice. Thus, my arguments will be separated in two sections. Firstly, the appellant will present that the ruling out of non-negligent causes should be a burden of medical professionals. And secondly, and as my last argument, the appellant will demonstrate how the majority at the Court of Appeals erred in their application of the standard of review. But just before doing so, I wanted to maybe weigh into Dr. Creedon's question about he followed the step, but is still would still find him liable for negligent acts. And I think that in this
We appear to have a delay.
case, we had to look at the facts, and we had
I'm
negligence.
just going to pause you there, counsel. We had a bit of a delay with your internet connection. And so the argument that you've made, we haven't been able to
Causes that
hear.
was brought upon by am I?
We might
hear
want
me
to
now?
just take 1 second, as there was a bit of a
Am I
lag.
in?
You've returned now, so there was a bit of a lag, counsel. So I'd just like you, if you could reframe that last point one more time.
Definitely. So as I was saying, I was just talking back with the question that Dr. Creedon was proposing with the opposition of our causation, finding him liable, but with following the steps. And we, and as the trial judge said, it was the compilation of the facts that was presented at the trial, the expert's opinion, and also the lack of non-negligent causes that could have occurred during the procedures. So the whole compilation of all of them made the conclusion trial judge liable for, the respondent liable for the negligence. As we know, in negligent claim, the burden of proof is placed upon the plaintiff. They must prove the elements of negligence and balance of probabilities. However, in cases of medical negligence, placing the burden of proof on the victim can be seen as unjust. Since the patient cannot usually know the details of their surgery preceded. In fact, the respondent in this case, as an expert surgeon, is generally in a better position to know the intricacies of the surgery.
Counsel, I have a practical question on that. So in medical negligence cases, often lawsuits are brought maybe a year and a half after the actual incident occurs. In that time, a physician does not remember the procedure in detail anymore. In fact, they have to rely upon notes 90% of the time. And so how can someone disprove negligence when they don't even recall the specific patient themselves?
Thank you for your question. I would say that, yes, it's been a times elapsed, but we still have, the question still remains, who was in the best position to make the choices and was awake and had the expertise to know what was going on during the procedures. And yes, we can take expert testimonies from the plaintiffs in the medical domain, but also the respondent who was there while the operation proceeded.
Counselor, I have a bit of an issue with the expert witness for Mrs. Armstrong. Now, it's my understanding that the expert witnesses have to be essentially peers and doing the same and are expert in that field. Now, the expert witness, Dr. Marcus Bernstein, commented that the chance of injuring the ureter was 0%. The question I have, number one, do you agree that that should be the case? And secondly, Dr. Bernstein has never had any experience with laparoscopic surgery. He has only done open surgery. So given the fact that he has never done laparoscopic surgery, and that was his statement that chance of injuring the ureter is 0%, do you feel that that's really a just conclusion?
Thank you for your question. To that, I would answer to the second question is because he is not an expert. That's why we think, and that's how the trial judge believes, that we should put the burden of finding the non-negligent causes on the respondent as well. And if you don't mind me asking, can you just repeat your first questions, please?
My question was, do you think it is reasonable to use Dr. Bernstein's opinion as an expert in which he has had no experience with laparoscopic colectomy? He has only done open colectomies, which is now no longer the standard of care.
Okay, thank you. And to that, yeah, I think you also mentioned the zero risk as well. And I think he was referring to while those procedures happened, he had no common knowledge of any outcome like this in his medical professional journey. And so that's why he mentioned zero risk. But there is a risk, and I think it's between the 1 to 2%. And those risk occurs when there's anomalies into the body of the patient or in other negligent causes as well.
So counsel, I'd like you to speak, in perspective, what, when you step back, what do you see this case as to us? Is this a misadventure, or was this simply circumstances beyond his control? I haven't yet heard from either of you what your position is in regards to what actually happened here.
Thank you for your question. My answer to that would be that what happened here is a case of, we have a patient who went under surgery with the probabilities of occurring a risk of injury of under 1%, 2%. We have the respondent, a doctor who had expertise in the domain, and we have a body that had no anomalies inside. So the risks were very limited. While this happened, we still have this prejudice that happened that needed our appellant to remove her kidney. Now, with all those facts compiled, we are asking, where's the problem? Was it negligence or was it non-negligent causes? And the important thing is the lack of non-negligent causes is what was the problem, because we can't show the non-negligence. Therefore, while the cross-examination was happening towards the respondent, Dr. Ward, he also admitted that he was not in view of the ureter at all times during the operation. And I think this is also the key factor in which we can say that negligence could have contributed to the prejudice.
So counsel, are you arguing that there should have been non-negligence considered in the trial judge decision?
They were non-negligence costing, like the dexterity.
But my question to you, counsel, is is your position that counsel, are you arguing that the trial judge's decision on the standard of review today should have included non-negligent exclusions? Because my understanding is the trial judge expressly excluded non-negligent aspects as a key aspect of our review today. Is that's a fundamental element we're looking at, is that the trial judge has actually expressly not addressed the non-negligence aspect of that procedure, as that is an argument that it could be an error to do so. And so my question is, what is your position on that point of law?
I believe that the plaintiff had the burden of proof to show her prejudice, to see what happened, and with the probabilities of 50 plus 1%. And then after that gives the burden of proof to show and demonstrate the defense, and to put out non-negligent causes. And they did, but they were not pertinent enough to be involved in the final judges.
And I completely agree with you. That's absolutely where that plaintiff and defendant discussion is. My question, though, rather, is the role of the trial judge in looking at, when we're looking at a standard review, to your point, where's the role of the trial judge in dealing with the non-negligence evidence or the lack thereof?
Can you just repeat that last phrase? It just cut off a bit, pardon me.
Yeah, so I'm asking you what your position is as to the correct review of the trial judge. For the trial judge, who, when we're seeing the appellant, how they've treated this, you have two levels of court. For us today, when we're looking at the decisions that are in terms of the decision maker, what was the correct role in dealing with non-negligent evidence or the lack thereof?
Okay, I'll answer my question. If it doesn't answer, we can refine. But and I'm talking about this later on also in my arguments about with the standard of review. But in this case, the standard of review, the trial judge was led with facts, expert testimonies, and lack of evidence to show permanently what happened during this case. So his review was to analyze all the facts, create with the experts of the respondent and the appellant set to define the standard of care. And within that standard of care, we identified that we have to identify and protect the uterer. And by identifying and protecting the uterer, it meant staying a distance from 2 millimeters away. So I think with all of that compiled and with the lack of evidence, that's what created the standard of review and as well the final decision.
Thank you, counsel.
And now just for precedence, in Snell, there was a case which causation was debated. The main concept could be utilized in medical negligence in cases regarding the burden of proof for determining the standard of care or discharging the duty of care. In medical negligence cases, the plaintiff should have the burden of proof that an act of negligence could have led to their injury, and they should succeed in proving their claim, unless the defendant could demonstrate reasonable non-negligent causes of the jury. The plaintiff would therefore have the legal burden of proof, but the defendant would have the burden of establishing the non-negligent explanations for the injury as a defense. And due to the lack of time, I'm just going to skip to my standard of review so we can talk more about it as well. In this case, the standard of care was well represented by the trial judge, like mentioned. The majority erred by limiting their conclusion on a correctness standard of review without including the notion of palpable and overriding errors. In Houston versus Nicolai, a palpable error is described as one as in plainly seen, and an overriding error is one sufficiently significant to invalidate the challenge finding of fact. Like previously stated, the trial judge had to make a conclusion, the facts and the evidence presented to him at the time of the trial. By listening to the experts, who all agreed that to meet the standard of care, reasonable surgeons should need to have, and I will now cite the steps that they took to define the standard of care. Identify the left ureter by locating it on the screen of the operating theater, and then use the medical approach, tweaking it or pushing the structures around it to ensure it moved. Pushed away the retroperitoneal structures, including the ureter, towards the head of the patient and for the colonic mesentery. Open the ligature to use it and to divide the colonic mesentery only after the previous steps. And the last steps, and this is where the emphasis is added, stayed away from the ureter towards the colon when using the ligature device to divide the colonic mesentery. So all the steps were talked about with the experts, and with that came the final conclusion that these steps guided and were essential to identify, protect, and avoid direct contact with or close proximity to the ureter while using an energy-emitting device like the ligature. Failing to do so would be considered an act of medical negligence by the surgeon, as agreed by the respondent's witnesses and by Dr. Ward himself. During the cross-examination, the question was asked, and I will quote again, what am I suggesting to you is that if you did use the ligature within 2 millimeters of the ureter, if you did, and you still don't know, but if you did, was that an error on your part? Do you agree with that? And to that, Dr. Ward said, yes. In conclusion, the trial judge's original decision was concluded by establishing a proper standard of care based on the facts presented at trial. Examining the evidence and by listening to the standard of care by listening to the expert's testimony, the experts, including Dr. Ward, all agreed upon the correct surgical steps that should take a responsible and prudent surgeon while operating the ligature device. This helped demonstrate that the respondent failed to stay safe distance from the patient's ureter while operating the ligature. And that safe distance was the 2 millimeters, therefore causing the appellant's prejudice. Also, accepting the majority's decision on this case would set a precedent that would not only deteriorate the authorities of trial judge in medical negligence, but it will also set an impossible to meet standards for the victims in medical negligence. We ask that this honorable court restores the judgment set out by the trial judge and restores the right approach on reasoning in cases of medical negligence in Canada. Thank you.
May I ask a question?
Please.
So do you believe that the standard of care should be perfection? So there was a definite risk, associated with this type of surgery to the ureter. I don't believe that the fact that Dr. Ward admitted that the standard of care should be he should stay away from the at least 2 millimeters away from the ureter. That's not necessarily that he is admitting that he is culpable. Do you not agree that he took the appropriate steps? And do you not agree that the risk, there was a risk, although very low, there still is a risk with this type of surgery? It seems to me that he did nothing egregious here to damage the ureter. Were there any witnesses, by the way, to suggest that he actually came within 2 millimeters?
For that last question, that's more of a question of a fact that was discussed at trial, and it's not the discussion that we'll have right now. But for the question of standard of care and for the zero risk, we do believe that it is not, what we're presenting here is not a zero risk approach of the standard of care. It's to look at the steps and not the goal, like was mentioned before. The goal was not to not injure the uterus. It was, the step was to stay and identify and stay a safe distance from any structures, including the ureter. So that was the step. And what happened between the pressure is that the ureter was hit. Therefore, by excluding all other non-negligent occurrences, the probability of the negligence from Dr. Ward was more predominant than other acts that could have occurred during that procedure. And therefore the conclusion then.
One final question, counsel. So thank you for answering the step versus goal comment. I appreciate that you circled back to that, so that's not lost on us. One thing I would like you to just confirm, in your opinion, would a competent surgeon acting without negligence, competent surgeons make mistakes that are not negligent, these things happen. Was this a competent surgeon acting without negligence? Yes or no?
I'm having some trouble hearing you. I think my Wi-Fi is not the best.
Not a problem. I'll repeat myself.
Sorry about that, please.
Just to conclude, as I understand we are short on time, I just would like your opinion, your position. Competent surgeons make mistakes that are not negligent. Negligence requires something more, as your friend has already taken us through today. In your opinion, then, was this a competent surgeon acting would a competent surgeon acting without negligence have made this error?
Okay, thank you for the question. I would say that the competent surgeon, am I back?
You're back.
Yeah, I'm so sorry for this. It's the first time it happens too. That's so unfortunate. But to your questions, and if I can answer, it's the competent surgeon here the competent surgeon here is that he would perform a surgery not with the zero risk, but by limiting the errors. And if the competent surgeon would bring non-negligent causes that could have occurred, he's the best put person to make those affirmations as well. So by putting them forward, it would create doubt in the mind of the conclusion, in which we can't conclude that it was his fault by negligence. So by showing the non-negligent, thank you.
Thank you. And don't worry about the lag.
Thank you. The court now invites counsel for the respondent to begin.
Good afternoon, Justices of the Court. My name is Veronica Attia, and I, along with my co-counsel, Tess Chambers, represent the respondent, Dr. Colin Ward. I will begin by addressing the error in defining the standard of care as the absence of injury, followed by discussing the standard of review. My co-counsel will then address Dr. Hagan's testimony, the problem with conflating causation and standard of care, and the issue with the plaintiff not ruling out non-negligent causes. In February 2010, Dr. Ward performed a colectomy on Miss Armstrong. He did so laparoscopically rather than using the traditional open method. The issue before this court is whether or not the Court of Appeal erred in reversing the trial judge's decision and concluding that Dr. Ward did not negligently perform the colectomy on Miss Armstrong. Your Honors, this is a case of a surgeon performing a procedure with a known risk. Steps were taken to reasonably perform the surgery, and despite Dr. Ward's best efforts, an injury still occurred. This leads me to my first argument. The trial judge defined the standard of care as the absence of injury. This is incorrect for two reasons. First, defining the standard of care by an outcome rather than the steps taken to achieve that outcome imposes a standard of perfection. Second, the cause of an injury is irrelevant to a negligence analysis if the standard of care was met. Defining the cause of injury as the standard of care leads to circular reasoning. My co-counsel will address the second issue later, but to address the first issue, the absence of injury is not a requisite to the standard of care for medical negligence. The standard of care asks whether the defendant behaved as a reasonably prudent and diligent professional should have, given the same circumstances. The Supreme Court of Canada and St. John and Mercier sets the precedent against using a retrospective analysis in reasoning. Considering whether a specific act or omission to act constitutes fault leads to an analysis based on results rather than means. Instead, we should ask whether a reasonable, prudent professional would have taken those steps. To take a results-based approach and conclude that avoiding injury is the standard of care is incorrect, as it imposes a standard of perfection rather than a standard of reasonableness. A surgeon is expected to have a high degree of knowledge and skill, and therefore owes a duty to their patient to use diligence and caution. The law holds surgeons accountable to a reasonable degree of care, but the standard of care does not guarantee results or require perfection. The trial judge erred in concluding that an injury constituted a breach of the standard of care because the standard cannot be based on absolutes. He defined the standard of care as identifying and protecting the ureter and avoiding close proximity or direct contact with the ureter.
So counsel, I'm just going to stop you there for a second. My understanding of the position of your friends who've made their arguments already is not that they're saying that there wasn't mistakes that can be made, that they expressly made submissions about it not being a standard of perfection. And so what I'd like to hear from you is, in dealing with this, coming in close proximity, my understanding is the expert evidence, which isn't, for us to question today, it's not a question of law, but the expert evidence said 1 to 2 millimeters was entered into, and that's a finding of fact. And we're not here to question the finding of facts today, as you know. But if he has come in to between 1 and 2 steps in this specific instance, rather with writ large, and that was, as the trial judge found, an essential fact that was found at trial. If that essential fact is there, how do you see that fitting into your argument there, which I see as you're setting up as the goal versus a step in the process? If it's an essential fact that is not before us to review today, that 1 to 2 millimeters was part of the trial judge's decision, without questioning that fact, because again, that isn't our role today, how do you reconcile that your client has a finding of fact that he came too close, notwithstanding that I appreciate his evidence at trial was that he was 5 centimeters away, but the trial judge did not agree. Ultimately, if it's an essential fact that your client was within 1 to 2 millimeters and that has been proven, pushing forward, what is it that you'd like the bench to consider in terms of whether this was in fact an error in terms of that step of perfection? Because clearly perfection did not occur. So I don't think we are considering perfection as having been factually relevant to this case. What I'm concerned about is, how do you reconcile this not being negligence with your client having a finding of fact as against him, which I appreciate you'll disagree with, but again, that is now on record, being within too close?
So what we're arguing is that the standard of care should be to protect and identify the ureter, which is what the trial judge found. And keeping 1 to 2 millimeters away from the ureter is a step, not a goal, because as Dr. Bernstein says, going within 1 to 2 millimeters guarantees the result of an injury. And in defining it in that way, it is essentially saying that with every injury, the standard of care would be breached. And that is imposing a standard of perfection. So what I'm saying is—
I'm just going to stop you there, though. My understanding is not that the trial judge asked for every incident. There's going to be realities, right? If there's a certain line that's you can't cross or you will injure someone. If that uncrossable line has been deemed 1 to 2% in the essential steps and has been crossed as an essential fact, how are we to look past that in terms of, we're not looking for perfection, but rather in terms of our standard of review and the standard of care that you're seeing coming in, if that mistake occurred, how beyond that are we to be able to look at that and see and follow your arguments? Because if I've read your factum, and if the rest of those submissions are regarding perfection, we're not, my understanding is we're not here today to look at whether it should be perfection or not. We're looking at the standard of review based on the fact there's a known error that your client has a finding of fact against them. And that is not, that whether it was in fact an error or not is not before that specific 1 to 2 millimeters is not before the court today. What is before the court today is in the trial judge's essential fact, how the appellants have dealt with that. So my question to you is, where do you see the trial judge's mistake with that, or do you? And if it's not clear and it's coming through, that's fine too. We're happy to wait. I just would like you to speak beyond that correction standard, because the essential fact isn't before us, and that at this stage could be an issue.
So if I'm understanding your question correctly, my answer would be that if 1 to 2 millimeters guarantees an injury, then that is what imposes the standard of perfection. And a standard of care is about the reasonable steps that the surgeon has to take to avoid injury. And in defining the standard of care as the avoiding injury or keeping 1 to 2 millimeters away from the ureter, we are neglecting to take into account that Dr. Ward did identify and protect the ureter. And that is something that the trial judge accepted. And so by identifying and protecting the ureter, Dr. Ward did take steps to avoid injury. And the fact that an injury occurred nonetheless does not mean that he was negligent.
So I'm to take you, just to ensure that your submissions then today are having a standard of 1 to 2 millimeters of an uncrossable line. You're asking the court to consider that imposing a perfection standard?
Yes, we believe that 1 to 2 millimeters would impose a standard of perfection under the assumption, and this is Dr. Bernstein's evidence, was that if going within 1 to 2 millimeters, that would guarantee an injury. And that would mean that any time that a surgeon went within 1 to 2 millimeters of the ureter, they would be in breach of the standard of care, even if they've correctly identified and protected the ureter. And that leaves no room for error. And we should not expect, and the law does not expect surgeons to be perfect. They just expect surgeons to take the reasonable steps that a reasonable, prudent surgeon would take in those circumstances.
Thank you, counsel.
The trial judge defined an injury as the breach of the standard of care. Such a definition of the standard of care is inconsistent with the jurisprudence, as I have noted in my submission, which emphasizes a reasonable standard rather than a standard of perfection. The surgery involved a common and known risk. Ms. Armstrong was aware of the risk, and Dr. Ward took the necessary steps to identify and protect the ureter. The standard of care was therefore met despite the injury to the ureter. The trial judge explicitly stated, quote, "I'm satisfied that the standard of care for a general surgeon is to identify, protect, and avoid direct contact with or close proximity to the ureter." Dr. Ward took the steps to identify and protect the ureter, and the trial judge accepted Dr. Ward's testimony that he kept 5 centimeters away from the ureter, as I have noted in paragraph 21 of my factum. Dr. Hagen stated that a surgeon has only successfully protected the ureter when it is not in direct view of the camera. Dr. Ward correctly pushed the ureter out of the camera's view and therefore protected the ureter. Since Dr. Ward took these necessary steps, an injury does not result in the breach of the standard of care. By focusing on the results of the surgery, the trial judge's analysis was expecting a standard of perfection rather than of the reasonable person. And the trial judge held Dr. Ward to the goal that a prudent surgeon would have when conducting the operation, rather than the means that the prudent surgeon would use to attain that goal. Based on the facts that my friend's own experts gave, coming within 1 to 2 millimeters of the ureter automatically causes injury. Using that logic, staying 1 to 2 millimeters away from the ureter is not a step, it's the goal. Defining the standard of care as the absence of injury neglects to acknowledge the steps that need to be taken to achieve that goal and the other duties required by the surgeons in the process. Defining the standard of care as the absence of injury implies that any surgeon that causes injury has breached the standard of care. With every injury, the standard would be breached. Additionally, a surgeon who does not cause injury has met the standard of care automatically. The emphasis is placed on the outcome rather than the means. Instead, the focus should be on the steps that were taken during the procedure. The standard of care should be to identify and protect the ureter, and the trial judge was satisfied that Dr. Ward did so. My next point regarding the standard of review is that the Court of Appeal correctly identified the error of law by part of the trial judge in his definition of the standard of care and reviewed this error on a standard of correctness. Justice Pachoco of the Ontario Court of Appeal stated that by defining the standard of care as the avoidance of injury, an absolute standard is imposed since liability follows with every injury. This definition results in circular reasoning. The failure to meet the standard of care causes injury because causing the injury is a breach of the standard of care. Therefore, it is generally an error of law to define the standard of care using outcomes or goals. An appeal court is not meant to question facts, but rather assess the application of the law. Whether Dr. Ward correctly identified and protected the ureter are not questions before this court. These are findings of facts that were determined by the trial judge who accepted that steps were taken by Dr. Ward to identify and protect the ureter. The question is therefore whether these steps that were taken were enough to satisfy the standard of care despite the result of an injury. I will now direct the argument to my co-counsel, subject to any questions you may have.
I have one question just back to this point. As you can see, I'm very stuck on the 1 to 2 millimeters. So one thing I'm going to be looking for from you and your friends in your submissions today is understanding that piece. My understanding now is within your argument is that 1 to 2 rule of past that point as an automatic injury, you're saying is perfection. However, if we take ourselves out of this space and we're looking at it, aren't surgeons supposed to have surgical procedures that are clear and show that at a certain point, if you go too far, you're going to cut off the arm? And when you're dealing with this kind of thing, there has to be a minimum point where if you get too close to a protected structure, that closeness has to be defined. As you know, lawyers, we like obsessive amounts of detail. And that is part of what we do is we review those. What does that mean? And without having a minimum standard of understanding what that means, how is the reasonable person supposed to determine that? My concern would be the flip side of that argument is looking at the person in surgery who's unconscious, is relying on, it's not good enough for a surgeon to be careful. They have to make sure they don't cross those uncrossable lines. And what I'm hearing, and I'd like you to clarify, is having an uncrossable line of 1 to 2 millimeters from a part of the body that has been identified as having to be identified and protected. That protection of 1 to 2 millimeters is minimal. And what I'm concerned as is you're saying if we are enforcing any limit of how close is too close, that's perfection. Or counsel, is there any limit that can be considered as reasonable?
So my answer to that would be that 1 to 2 millimeters is essentially synonymous with causing injury. Because according to Dr. Bernstein's testimony, there is a 0% chance that an injury would not occur if you were within 1 to 2 millimeters. And that is what I mean when I say it's a standard of perfection, because it leaves no room for error, and it neglects the fact that Dr. Ward did take the necessary and the reasonable steps to avoid the injury, and nonetheless an injury occurred. But he did identify and protect the ureter. And my second point to that is in Dr. Hagen's testimony, he explains the process of removing the ureter outside of the view of the camera. And he says to correctly identify the ureter, you would be about 3 to 4 centimeters away, and you would not be within that 1 to 2 millimeters. So really the only evidence that there is of Dr. Ward coming within 1 to 2 millimeters is the injury. And the trial judge accepts that Dr. Ward did correctly identify the ureter. So essentially okay. Thank you.
Good afternoon, Justices of the Court. Firstly, I will address why Dr. Hagen's testimony of the standard of care should be favored over Dr. Bernstein's. The expert evidence from Dr. Hagen showed that Dr. Ward met the standard of care. The standard of care, as established by Dr. Hagen, was to take reasonable steps to avoid contact or close proximity to the ureter. Based on the facts of this case, it's uncontested by Dr. Hagen's testimony that Dr. Ward took such reasonable steps as identifying the ureter, pushing it out of the way, and continuing to reconfirm its location out of the way of the ligature. Dr. Hagen has claimed to complete this same procedure, a laparoscopic colectomy, approximately 60 times per year, using the ligature device, quote, thousands of times. Dr. Bernstein's a general surgeon and has performed weekly colectomies for the past 30 years. However, he does not do this procedure laparoscopically and is not as well versed in the ligature device. It was only from Dr. Bernstein's testimony that it was believed that coming within 2 millimeters of the ureter with a ligature device is said to have breached the standard of care. Nevertheless, Dr. Bernstein's evaluation of the standard of care was favored in place of Dr. Hagen's, even though Dr. Bernstein himself testified that, quote, Dr. Hagen would be in a better position than me to talk about how a laparoscopic surgeon achieves this goal. Although an uncommon occurrence, Dr. Hagen explains that a ureteric injury is a known risk of the operation and is satisfied that Dr. Ward took these steps to avoid such injury. In Dr. Bernstein's testimony, he stressed the significance of re-identifying the ureter continually throughout the surgery, which was a step shown to be completed by Dr. Ward. He also stated that the risk of injury in a routine colectomy surgery without any abnormalities of the colon should be zero, as Dr. Creedon addressed. The trial judge dismissed this assessment of risk as it was a personal opinion not backed up by evidence. However, he still agreed with Dr. Bernstein's evaluation of the breach of the standard of care. All doctors agreed this was a routine surgery. There were no abnormalities in the appellant that would make her more susceptible to the injury. Dr. Ward was clear on the instructions to identify and protect the ureter before proceeding with the colon removal, and to continuously do so throughout the procedure. Dr. Ward has claimed to perform about 50 colectomies prior to Ms. Armstrong's, either surgically or laparoscopically. It's obvious here why we're here, that something went wrong during the surgery to cause this injury. But there's nothing in the facts nor the expert evidence to suggest that this was the fault of Dr. Ward other than the injury itself.
On that point, counsel, your friends have submitted to us that it should be on the physician to start ruling out non-negligent causes, given that they are in the more advantageous position to do so. I would like to know what your position is on that, and especially given the fact that patients don't have the medical expertise to actually prove negligence, often that therefore requiring expert evidence, which becomes very costly. And it seems like we've put in place some sort of system where it's prohibitive for injured plaintiffs to actually prove negligence against a physician who is presumably insured.
Mm-hmm. Yeah, I will go into this point a little bit more later on in my oral argument here, but the reason I think in our submission the plaintiff should bear the burden is because this is not our argument. We are not proposing that this is even the fault of Dr. Ward, and why should the burden be on our plaintiff to rule out the non-negligent causes? Justice Kanji, as you noted, this surgery occurred a year to a year and a half prior to this hearing, and they are purely relying on their notes. And how are they expected to remember the exact steps that they took beyond their notes when they may even have trouble remembering who this patient is?
But on the flip side, what if you have a patient who might be under general anesthesia who has zero consciousness of a procedure itself? And so relying upon your notes seems to be a better scenario than a plaintiff essentially trying to guess what happened. And so I'm just curious at how you grapple with the legal point of who bears the burden of proving or disproving negligence in a case where one side has a clear upper hand, and that's usually the defendant.
Yes, but in our submissions, we're not at the point where negligence ought even be addressed, which comes into my causation analysis, because in our submission, there is no breach in the standard of care. As my co-counsel here was saying, the goal of the surgery is to not come within this 1 to 2 millimeters. And Dr. Ward, as proven by the trial judge, is he took the necessary steps to both identify and to protect it. So to go into non-negligent causes is not our claim. This is the appellant's claim. So
But
for
your job as a respondent is to respond to it. And so if they're putting that forward, if that's something we want to consider, I'd like to know what your position generally would be on that.
Yes, I understand. And we did, two of our experts, Dr. Robinette and Dr. Klotz, did address two alternative theories, and these were thus rejected by the trial judge. But the appellant has not brought up any other suggestions. And even their expert, they have Dr. Bernstein as their retained expert, and he did not bring up any other suggestions either.
So just to build off that point, counsel, why would a trial judge be wrong then for failing to consider things that are not brought into evidence? There does not seem to, when we look at the trial record, there are aspects here that you're saying that it would have been perfection and it was required to be, protecting it, fine, and that his notes are what we're relying on here. Sure. However, when we're looking at that, the trial judge has to look at the evidence that your client brings or fails to bring in front of them. And the decision needs to deal with the actual steps in front of them. Why would that be an error for the trial judge not to consider things that are not in evidence?
Why would it be an error? Sorry, can you just repeat that for a second?
Why would it be wrong for a judge to consider something that's not in evidence before them?
Well, how can they say that in the absence of any evidence other than the injury that it was due to negligence? I don't know. We're not saying that there was negligence in this case. We're saying that there was a breach, and there wasn't even a breach in the standard of care because Dr. Ward, as shown by the trial judge, he met the standard, or he met the steps of identifying and protecting the irritor. So if I may move on to my second point here of causation and the standard of care, and how these are not two equivalent points. In the trial decision, the standard of care was considered in relation to the injury, preventing an independent analysis. The trial judge found that the standard of care is breached when the ligature comes within 1 to 2 millimeters, which is inconsistent with the definition of the standard of care, which speaks to the process of avoiding injury. The causation analysis is not necessary if there is no breach in the standard of care. Both the causation analysis and the standard of care analysis are considered under the same heading in the trial decision, which causes this problematic overlap. The standard of care asks what reasonable, prudent behavior can be expected of a surgeon carrying out a colectomy in order to avoid injury to a ureter. The trial judge completed the two. The Court of Appeal judge says, where the nature of the injury is relevant to what happened, it's not an error to consider that the injury in resolving whether the standard of care has been breached. However, since the trial judge misconceived the standard of care, he had to resolve the what happened. Had the trial judge properly assessed the standard of care, it would not be necessary to complete the two. Causation does not need to be assessed unless we identify what the breach in the standard of care is. Only once this breach is identified do we move on to causation. Since there's no breach, we need not move on.
Counsel, is it your position that a trial judge with a med mal case before them should not be asking what happened ever as part of assessing a standard of care?
Well, if there is said to be a breach in the standard of care, then obviously, yes, the what happened is necessary. But it's not important in my opinion.
So just to clarify, your submissions today are that the trial judge's decision we're reviewing before the trial judge, it's not important for him to ask what happened in this matter.
Well, what happened are the steps that he took. And these are the identifying and protecting the ureter. And those steps, as he said himself, were met. So it's the what happened is more important when there's a more direct causal link. But these steps were actually shown to be taken. So causation does not need to be assessed unless we identify the breach. and it's there are cases where negligence alone can prevent a goal from being achieved, and in my submission, this is not one of those. And then I'll go into my non-negligent causes again here. I know I addressed it earlier, but I have a bit more that I don't think I said quite the way I wanted to. So if the injury is determined to be caused by negligence alone, the judge must consider and rule out these non-negligent causes. The trial judge analysis did not consider these other non-negligent causes that may have injured the ureter. To assume the position that this injury could only be caused by negligence is an exceptional circumstance and requires the process of eliminating these other potential causes. This is a case of a surgical procedure requiring many steps, all of which were satisfactorily performed as found by the trial judge. My friend provided no alternative non-negligent causes and does not dispel their burden. This case is one where the standard of care is said to have been automatically breached by coming within 1 to 2 millimeters, and the trial judge rules that this is purely done out of negligence and fails to consider any alternatives. In doing so, the judge is insinuating that in every case and every circumstance that an accused comes within 1 to 2 millimeters, they have done so negligently and will be held liable. Surgeons cannot guarantee outcomes. Unfortunately, many surgeries yield tragic results. A surgeon should not be automatically deemed negligent because a patient was injured. Rather, a surgeon is obliged to take certain steps or precautions to avoid injury. If those steps are taken and an injury still occurs, the surgeon cannot be held liable for negligence. In this case, the standard of care should be defined as identifying and protecting the ureter, 2 steps that Dr. Ward was found to have met by the trial judge. Keeping away 1 to 2 millimeters from the ureter and avoiding injury is the goal of the surgery, which, if not met, is not an automatic result in negligence. By meeting the standard of care as we have defined, causation analysis is not necessary. My friends have also not identified the breach in the standard of care. The only evidence before the court, which is not sufficient evidence, is an injury, which is not sufficient evidence to hold Dr. Ward liable for negligence. To use avoidance of injury as a step in this procedure would be to impose a standard of perfection, which cannot be expected from professionals. Surgeons should only be held to a standard of a reasonable, prudent surgeon in the same circumstances.
So counsel, my favorite thing is 1 to 2 millimeters, as you know.
Yes.
And I just want to clarify there again. So as your submission then, that having any sort of minimum criteria of too close is too close, and to define that, you're saying is a submission of perfection then, is creating a standard of perfection, because my understanding here is, again, the injury is being made, that it's a finding of fact that the trial judge found that the ureter was not touched directly, that thermal injuries can occur, and it was a finding of fact based on the evidence and weighing the expert evidence in front of them. Mm-hmm. That finding of fact was made, that the essential fact was not that there was an injury, but that the injury occurred contextually within that 1 to 2 millimeter minimum range. Yeah. From a thermal aspect here. Now, my question to you is there any part of that you feel is an error then? Is it not logical from the trial judge's perspective to be able to have a minimum reasonable standard that once crossed is not enough to really be protective, even though that step may have been attempted to have been taken?
Well, as Veronica said earlier, Dr. Hagen submitted in his testimony that by identifying and protecting the ureter, it should be 3 to 4 centimeters away. So that is a step, and ideally would have been what happened. In this case, unfortunately, something went wrong where he came within this 1 to 2 millimeters. But what we're submitting here is that coming within 1 to 2 millimeters is synonymous with causing this injury. So it cannot be a separate step unless you're imposing that that a step in this procedure is to not cause injury. In my submission,
So I'm just going to stop you there for a second. You just said that 1 to 2 millimeters is synonymous with causing injury. And I think that's the part that the bench is struggling with today, okay, is if 1 to 2 millimeters is synonymous with causing injury, would it not make sense then that crossing that 1 to 2 millimeter threshold amounts to negligence?
No, it wouldn't. In my submission, it wouldn't make sense because that's the goal of the surgery. It would be a step to avoid everything that you would want to stay. Ideally, you would want to stay as far away as possible from this ureter. As Dr. Ward said, he stayed 5 to 15 centimeters away. Coming within this is not favorable, but it's still something that can happen as we've noted, there is no, you cannot expect perfection. There's no zero risk in this procedure. And
so then, counsel, just to follow that point, if there's no zero risk, am I to understand your submissions correctly then, is if he had actually directly touched the ureter, destroying it at that point, would that have been considered negligence in your submission?
well, in this hypothetical, did he do so intentionally, or did he take all the steps to avoid doing so?
Intention is not part of the negligence aspect.
Okay,
So
well,
when
I'm sorry to cut you off, but did he take all the reasonable steps to avoid doing so?
I'm not asking you that. I'm saying if he had gone straight up with a scalpel and cut that ureter, according to your submissions, your reasoning behind that is it would still depend on the steps and potentially intention now as to how he got there?
Well, I believe if he took the steps to avoid doing so with the goal of not injuring the ureter, then that would not be a breach in the standard of care.
Thank you.
So from my perspective,
yes,
with respect to Councillor Kate Agabang's statement, that if the surgeon did injure the ureter directly, that would not necessarily not be the standard of care, but what would be negligent would be the fact that he did not recognize that the ureter was directly injured, causing a leak. And it would be incumbent on the surgeon to recognize that and to repair it. If he did not, that would be negligent. In this issue here, the ureter, assuming that the ureter, that 2 millimeter margin was breached, there was no obvious recognition by Dr. Ward that had occurred. If he had breached the 2 millimeter margin and had recognized that he had breached the 2 millimeter margin and did nothing about it, that to me would be negligent. So the fact that he took all the necessary steps, and it implies to me that he meets the standard of care, and the fact that the ureter was injured, he did not recognize it, if indeed that did happen, and it would be incumbent to him, if he did so, then he would have to take steps and to address that issue. But none was taken because he did not realize that he had breached that 2 millimeter mark. This is not, in my opinion, not negligent.
I think also we need to consider, though, that the trial judge's evidence and the essential facts are not an issue before the court. And as we are going with respect to the bench's opinions, what was not before the court has not been able to be considered. And what we're looking at here is the argument of the standard of care. And in that standard of care, my understanding from Ms. Chambers is that the argument about the standard of care is that there should not be a automatic negligence zone regarding to this space. Having said that, from our friends who have spoken previously, the issue is that surgeons are held to a higher standard and are expected to not cause injury as a aspect. That causation of injury piece is part of the discussion here of whether in this specific instance is what caused this injury being too close is part of the what happened essential fact aspect, and that's for the bench to consider. And as you can see, our bench may need to have some private discussions before our ruling today. So thank you, counsel, for your submissions.
yeah, thank you.
The court now invites counsel for the appellant to begin their optional 3-minute rebuttal.
Thank you. We would like to take this opportunity to remind this honorable court the way in which the law currently operates makes it very difficult for the victims to be compensated after having sustained injuries at the hand of the doctor, unless they can prove recklessness. This would have to give reasons or counter arguments to prove that they are the patients in the wrong, and to prove to the respondents why they are wrong as well. So it's an impossible to meet burden of proof. It doesn't make logical sense for the victim to demonstrate why their case could be entirely wrong. And a patient doesn't base their faith on the means of the doctor in which they proceed, but rather the success of the operation, especially with a low risk procedure like the removal of the colon. The reasonable doctor is held at a higher degree of reasonableness due to their expertise. The steps that were discussed were to identify, protect, and stay away from the ureter. The 2 millimeters is an example of the thermal spread that can occur. So we know if the thermal spread has a distance of 2 millimeters, we're going to make the reasonable doctor will not go close to that or else injure the patient. For all of those reasons, and for the one expressed by my colleague, we thank you, Your Honors, for hearing our oral submissions today.
This concludes the matter of Armstrong against Ward. Thank you all. Judges, I would like to remind you to send your score sheets to the email that I will be putting in the chat. You're welcome to go see the semi-final rounds and the final rounds that will start at 2 and then later at 4. Thank you.
Just one note to all of you participating, doing moots virtually is really, really hard, and doing moots virtually from home, I've got kids screaming from the basement right now. All of you did excellent. We're not going to give you individual feedback here. That's for the score sheets that you'll see, but this is a uniquely difficult year to be mooting, which is already incredibly difficult with everything else that you have going on. You should all be very proud of yourselves for what you've done today. It was very impressive. And I got to say, I have colleagues, so I'm going to refer them to each of you later on and say, take a lesson. Well done.
I have to echo that and briefly say you're developing skills now that litigators are also trying to figure out in real time. So you're quite well positioned for the future of what our profession is going to look like.
Especially with the difficult bench you got. We were very difficult for you, and on all of that, very chatty. Justices do that all the time, and it's throwing, as you can see. Please don't let that shake your confidence about how you did here today. Sometimes judges do it just to see how well you know your argument. Sometimes they're very interested. Sometimes they bring up irrelevant things that you're like, not what I need to deal with right now. So just all of you manage the bench, which we purposely made difficult for you. So with that, I just wanted to say again, really, you should be I know it's really startling when it happens. So it's, you did very, very well managing us.
I'd like to echo that, and I'm certainly there's enough responsibility as a judge. I can't imagine the stress that all you guys must be under in these circumstances, and I wish you all the very best of luck in the future. And I hope I won't have to deal with you in a malpractice case going forward. Thank you. Well done.
Thank you so much for coming to watch today. This is my first time mooting, so we were very nervous, but you guys made it fun. So thank you so much.
Yeah, thank you so much. I'm pretty sure we're all 1Ls too, so thank you for taking the time to listen to us today.
Well, you guys are all naturals with oral advocacy. Oral advocacy just feels this awkward. It just does. As you do it 10 and 20, 15 years, everyone is all saying oral advocacy, you get up there because there's always two sides of a good case. Otherwise, people fail to settle it at a court. And so if there's two sides of a good case, you should be able to argue it into the ground either way, but that doesn't mean it is an easy thing to do with strangers, with people watching you in the courtroom. Hello, spectators. This is just regardless of any of the individual comments and feedback, to say, really, truly walk away with your head held high. Mooting is brutal. Pandemic mooting is brutal. And your bench were drama. So good for you. Okay, so I think, is that the expectation now, Ms. Moderator, that we're moving to the next phase?
Yeah, so this session will actually come to an end. If anybody wants to go see the semi-final round, it will start at 2. Otherwise, I've put the email in the Zoom chat, and that's where the score sheets should be sent for the feedback. Otherwise, you're welcome to stay on this session, but I think it'll end at 1.
good luck, guys. I'm off to evaluate now, but honestly, congratulations.
Thank you.
Thanks, everyone.
Thank you very much.
Thank you.
Good luck, everybody. You all did a great job.